As already we have finished 18 questions on property law. So, in this video, we'll discuss question number 19 and its relevant answers. So, the question is state and explain briefly the law laid down in the Transfer of Property Act about fraudulent transfers. The very answer to this question we found under the provisions of Section 53 of the Transfer of Property Act. So the very Section 53, provides that there must be a transfer of immovable property, and secondly, the transfer must be made with intent to defeat or delay the creditors, and that is otherwise called fraudulent transfer. So, the very exception to this is that if the transferee and good faith and for consideration is protected, that is, the creditors cannot set aside a transfer made to a person who has acted honestly and has paid consideration, then it would not be considered as a fraudulent transfer. So, fraudulent transfer as such under this section is of two parts. The first part lays down that every transfer of immovable property made with intent to defeat or delay the creditors of the transferor shall be voidable at the option of any creditor so defeated or delayed. To take one illustration, it would be clarified in a better way. And as such, the very illustration is that A, who is heavily indebted and against whom suits for the recovery of debts are going to be filed, sells his house to save it from being attached and sold in payment of the debt. If B knows of A's fraudulent intention, the sale to B is liable to be set aside at the option of the creditors. It will be seen that the rights of a transferee in good faith and for consideration are not affected even though the transfer is made with intent to defeat the creditor. And the very second part of this section lays down that every transfer of immovable property made without consideration with intent to defraud a subsequent transfer shall be voidable at the option of such transferee, but no presumption to defraud shall necessarily arise by reason only that a subsequent transfer for consideration was made. So, in that connection, we would like to discuss one leading case, and that is Imani Apparao versus Gollapalli Ramalingamurthy, and it was a case of 1962 decided by the Supreme Court. So the very material facts of this case were that one, the transaction in favor of the plaintiff was the result of a fraudulent plan to which both he and the defendant agreed. This transaction was effected with the mutual consent of the vendor and the vendee to defraud the creditor of the vendor. And thirdly, so the transfer was not supported by any consideration, and the transferee agreed to act as the Benamidar until the transferor required him to convey the properties to his sons. And fourthly, the object intended to be achieved and the fraud initially contemplated by both the parties to the suit had been achieved and the creditors of the defendant had been defrauded. Thus, both the parties to the suit were confederates in the fraud and were equally guilty of fraud. So, the Supreme Court held that there can be no question of estoppel for the defendant from pleading in the suit fraud and absence of consideration. The reason is that the fraud in question was agreed by both the parties who had assisted each other in carrying out the fraud. And second observation made by the Supreme Court in this leading case in 1962, when it is said that a person cannot plead his own fraud, it really means that a person cannot be permitted to go to a court of law to seek for its assistance and yet vest his claim for the assistance of the court on the ground of his fraud. And thirdly, the plaintiff can be said to be guilty of a double, double fraud if he joined the defendant in his fraudulent scheme and participated in the commission of fraud, the object of which was to defeat the creditors of the defendant. Also, he committed another fraud in suppressing from the court the fraudulent character of the transfer when he made out the claim for recovery of possession. The convenience in his favor was not supported by any consideration and was the result of the fraud and therefore conveys no title to him. Yet, if the plea of fraud is not allowed to be raised in defense, the court would in substance be giving effect to be the document which was void ab initio. Therefore, the paramount consideration of public interest requires that the plea of fraud should be allowed to be raised and tried, and if it is upheld, the state should be allowed to remain where it rests. the adoption of this course is less injurious to public interest than the alternative course of giving effect to a fraudulent transfer, as it was pronounced by the Supreme Court in 1962 on this leading case, Imani Appa Rao versus Gulapati Ramalinga Murthy. And now we'll go to the exact meaning of creditor as we found under section 53 of Transfer of Property Act. The word creditor has been used in this section in somewhat wide sense. Thus, it includes all those who are creditors at the date of transfer as well as those who became creditors subsequent to the date of fraudulent transfer. Further, it includes not only those creditors whose claims have yet to be proved in court. On the other hand, a person who claims an unliquidated sum for damages for tort or breach of contract is not a creditor nor a person whose claim for a debt has been time barred. So, now we'll go to another factor, that is the intent to defeat or delay. So, it is a part of fraudulent transfer, and in that connection, we would like to discuss one important leading case. And before discussing that, we will discuss the factors relevant to a conclusion that the transaction is bona fide. So, the factors are the debtor sells all his property, keeping nothing to himself. Secondly, the consideration is grossly inadequate. And the third factor, the transfer is made secretly and in haste. And the fourth factors would be the transferor puts all his property out of the reach of those who might become his creditors before embarking on some hazardous enterprise. So, each of the above factors must be considered along with other circumstances of the case. However, suspicious a transaction may be, there must be cognate evidence of fraud. The mere fact that debts are due from the transferor is not by itself sufficient to establish a fraudulent intention. It must, however, be noted that if a person acquires property for value and in good faith, that is, without being a party to any design on the part of the transferor to defeat or delay creditors, his right will not be affected, although the transferor's intention might have been fraudulent. In fact, whenever Section 53 is applied, it is the transferee who ultimately suffers, provided he knew of the fraudulent intention of the transferor. The knowledge and intention of the transferee as the main factor. So, in the very leading case, Pal Malal versus South Indian Export Company Limited, the Madras High Court made the observation that a being in financial difficulties wished to convert his property into cash so as to conceal it from his creditors. B. Being aware of S. Object assisted him by purchasing the property. The sale was voidable under this section, as it was pronounced by the Madras High Court in this leading case, Pal Mahalal versus South Indian Export Company, and in relation to the very intent to defeat or delay, which is a part of fraudulent transfer. So now we'll go to another important leading case, and that is Hanipa BV versus Punnama, and it was also a case of Madras, and in this particular case, the Madras High Court held that the transfer which defeats or delays creditors is not an instrument which prefers one creditor to another, but an instrument which removes property from the creditors to the benefit of the debtor in order to take out of the case from the operation of Section 53. It is essential that the debtor must not reserve any benefit for himself. If the debtor sells property to another creditor to discharge the debt due to him, and the price obtained is considerably in excess of the debt discharged, this should be evidence of intent to defraud, as it was held by the Madras High Court in this leading case, Hanifa Bibi versus Punnama. And now we'll go to another important leading case, and that is relating to good faith and consideration. And in that connection, before that, we would like to discuss another important leading case in relation to intent to defeat or delay, and that is Abdul Shukar Saheb versus R.G. Papa Rao, and it was a case of 1963 where Supreme Court made the observation that the terms of Section 53 Clause 1 are satisfied even if the transfer does not defeat but only delays the creditors. Therefore, the fact that the entire property of the debtor was not sold does not by itself negative the applicability of Section 53 Clause 1 unless there is cognate proof that there is other property left sufficient in value and of easy availability to render the alienation in question immaterial for the creditors, as it was pronounced by our Supreme Court in this important leading case, that is Shukar Saheb versus R.G. Papa Rao in the year 1963. And now we'll discuss another important fact relating to fraudulent transfer, and that is good faith and consideration. And regarding that, if the creditors establish that the transfer was made with the object of defeating them, the burden shifts on the transferee to prove that he had paid a fair price and that he was not a party to the fraud. The term consideration, as used in this section, has the same meaning as it has in the Contract Act and therefore excludes natural law and affection. Transfers for natural law and affections are treated as transfers without consideration, where the fraud on the part of the transferor is established. The burden of proving that the transferee falls within the exception is upon him, and in order to succeed, he must establish that he was not a party to the design of the transferor. So also he did not share the intention with which transfer has been effected, and so also he took the sale honestly, believing that the transfer was in the ordinary and normal course of business, as it was also observed by the apex court in the same leading case. Abdul Sukkar Sahib versus R.G. Bapa Rao in 1963 by the Supreme Court. So, transferee was not a party to the design of the transferor, so that he did not share the intention with which the transfer has been effected, and so he took the sale honestly, believing that the transfer was in ordinary and normal course of business, and it was as pronounced by the apex court in the above mentioned leading case, Abdul Shukar Sahib versus R.G. Papa Rao in 1963. So, under certain circumstances, the plaintiff should share that intention, and for one of the circumstances that we would like to analyze here, that is the property situated at Vijayanagaram, but the document of sale deed was registered at Chennai. This was with a view to keep the transaction secret from the creditors, and the plaintiff was as much a party to the secrecy as the transferor. So, in this circumstance, it stands to reason that the plaintiff must be fixed with notice of the design in pursuance of which the transfer was effected. If the object of a transferor who is heavily indebted was to convert his immovable property into cash for keeping it away from his creditors, and knowing it, the transferee helped him to achieve this purpose, it has naturally to be held that he shared that intention and was himself a party to the fraud. Therefore, it has to be held that the plaintiff was not a transferor in good faith, and that the transfer itself was a scheme by the transferor with the knowledge and concurrence of the transferee to put the property out of the reach of the creditors. And now another part regarding fraudulent transfer that we'll discuss regarding the very nature of suit as provided under 21 Rule 63 of the Civil Procedure Code. So a creditor suit to avoid a transfer must be a suit on behalf not only of himself but of the whole body of creditors under 21 Rule 63 of Civil Procedure Code. This rule has been laid down with a view to protect the debtor from multiplicity of suits by each and every creditor if there are more than one in a suit to avoid a transfer under this section. The issues to be framed are: was the transfer made with intent to defeat or delay the creditor? And secondly, if so, was the purchaser from such a debtor a transferee in good faith and for consideration? So the onus of proving the first issue lies on the creditor, and if that is established, the onus of proving the second issue is on the transferee. So the very suit why the transferee that we will discuss as under 21 Rule 63 of the Civil Procedure Code, and in that connection we'll also discuss the same important leading case Abdul Shukar Sahib versus Arji Papa Rao in 1963, the pronouncement of the Supreme Court. So, a transfer which is avoidable under Section 53, Clause 1 of the Transfer of Property Act 1882 can be avoided not only by a suit instituted by a creditor challenging the transfer on behalf of himself and other creditors, but also by way of defense to a suit under 21 Rule 63 of the Civil Procedure Code by a transferee who is also the claimant whose petition was rejected in the summary proceeding under 21 Rules 58 to 61 of the Civil Procedure Code, as it was held by the Supreme Court in 1963 in the very important leading case relating to this section as relating to fraudulent transfer, that is Abdul Shukar Sahib versus Arji Papa Rao in 1963. So, in our next upcoming video, we'll discuss question number 20, and that question number 20 asks, explain the acts which will be deemed to constitute part performance as per the doctrine of part performance. The very answer to this question we found under section 53A of Transfer of Property Act 1882.